we need to be able to define, because this is jurisprudence, we must be able to define a concept. What is a rebel enclave? What does that mean when we talk about a rebel enclave? What does that mean? We need to be able to delineate that. We need to be able to know exactly what we mean. So when we talk about rebel enclave, as usual, I will want us to resort to a dictionary meaning of it, because we know what a rebel is. A rebel is someone who it's against the established order. That's a rebel. That's what a rebel means. It's against its established order. He doesn't want to have any dealings with an established order. He or she is angry with the establishment. And so because of that anger, he or she doesn't want to have anything to do with the established place, established position. And so for that reason, there is the likelihood of not, there is a likelihood of not agreeing to what is going on in that establishment. There's the likelihood of not having anything to do with. So the definition of a rebel enclave is an unrecognized space or territory controlled by insurgents. Rebel enclaves are governed through private authority, depending on illicit channels of trade and communication. I'm going to take that definition again. A rebel enclave is an unrecognized space or territory controlled by insurgents. Rebel enclaves are governed through private authority, depending on illicit channels of trade and communication.
I don't know if you heard me the last time. You're muted, so we can't hear you. We just want you to know that we can't hear you. That's it.
I'm sorry. You didn't hear me for some minutes because there was something at my own end here in the faculty. I'm in the faculty and there was something at my own end. That's why you didn't hear me. So I'm sorry. We'll continue the conversation. I was giving you the definition of a rebel enclave. So I think I need to take that again. A rebel enclave is an unrecognized space or territory controlled by insurgents. Rebel enclaves are governed through private authorities, depending on illicit channels.
14th Avenue Studio.
So can you please mute yourself? If I do that, can you please mute yourself? You are disturbing the class. Can you please mute yourself? So I have given us the definition of a rebel enclave, and I'm sure it's being recorded, so which means you can have a replay. So what we are going to look at today is problems of law in a rebel enclave. Law thrives in a state of order. Law thrives in a state of a measure of governance. That is, there is order, there is governance, and that's how law thrives. And of course, law happens and because law happens all the time to positions of people, that is, there is always a group of people that law will take care of. So, because of that, what are now the problems that we're likely to encounter in a rebel enclave? The first thing that you will recognize about is it's taken from that definition, which is it is an unrecognized space or territory. That is, that portion of the state is not recognized. And because that portion is not recognized, it is impossible for law to be effective in that portion of state, because the definition says a rebel enclave is an unrecognized space or territory controlled by insurgents. So insurgents are folks that are angry with the state, and they have occupied a space or territory. And so it is impossible for you to make law to be effective, because which law are we talking about? Which law do we want to be made effective in that kind of scenario? So that is why, that's the first thing we're going to see, that it is impossible for law to operate because that space is unrecognized. That's two, insurgents. In international law, and when we talk about international law, we're talking of international humanitarian law. There is what we call, there are treaties which the United Nations have formed. We have Law of Geneva, and then we have some other treaties that have been formed. And because of those treaties, there is a special consideration, concerning insurgents, how they will be treated under the law. It's always that. And so the insurgents will certainly not agree to the law that is expected or supposed to be used in that territory. And so the problem too we have is a problem with the insurgents. That is, how does law deal with insurgents? Our local laws with military incursions will say that insurgents should be crushed. But international law will say otherwise. International law will be talking of a way of bringing the insurgents back to the fold. So the second problem we will be having is, how does law deal with insurgents? Because we have international law and we have national law. Of course, as a student of international law, I know that international law will take precedent over the national law. That let's take an example of the Nigerian state, that the Nigerian state will be forced to obey international law. That's what the Nigerian state will, because she has signed those treaties, and she had signed the additional protocols to the Geneva Conventions of 1949. So she will be forced to obey that treaty. So going from that definition, now, rebel enclaves are governed through private authority. Who are those private authority? They are the insurgents. And they corner. And for us in Nigeria, which is a good example now, you must have read in the newspaper how insurgents will take over a village, and they'll put their flag in the place. And they will tell the villagers that they must obey them. And the other side of the definition says, depending on illicit channels of trade and communication. And you find that these insurgents, they collect tributes from the villagers, you know, and of course, with the aid of technology, the world has become a global village, and they are able to communicate, you know, even though the Nigerian government has tried in some instances to make sure that communication is broken down in certain parts, you know, where these people operate, but you find that it's still not working as it should. So when we look at problems of law in a rebel enclave, the first thing that comes to us is that law becomes ineffective and law becomes impotent. You know, law cannot exercise its authority and power as it ought to, because law, as we always say, should be able at all time and for all intent and purposes to be obeyed. But you find that the kind of law that will be at work in those rebel enclaves will be not the law that I and you signed for, but the law that the rebels are formed with that enclave, you know, with that space that they are controlling. And this is the problem. Because of what is happening, then you find that law becomes ineffective. And now, because also in a rebel enclave, at times, there is no defined hierarchy of structure. They have leaders. The rebels do have leaders. If we can take example of Osama bin Laden and the rest of them, and we can see the fight between IDF and in Gaza, and how the IDF is eliminating the leaders. So, but these leaders, yes, they're leaders in that enclave, and they have a command. But for us, because what they're doing is unrecognized, the law will not be able, the law that is the law of the state, will not be able to recognize what they're doing and will not want to recognize their activities. And because the law, in a way, is feigning a sort of ignorance against these folks, then you find that how do you now enforce the law in those places? So it becomes a bit of impossible for us to enforce law in that enclave. Because I started the lecture and I had a break, I'm going to stop now, and I'm going to give room for us to ask questions. So we can go ahead and ask questions so that I will answer our questions.
Good morning, ma.
Morning.
Yeah, I observed that you were very careful in the words that you use. You said insurgents. You didn't say terrorist. So I'm wondering, in terms of how international organizations relate with this kind of issue, is there a difference between insurgents and terrorists, as it were?
United Nations have a treaty on terror. And even us in Nigeria, we have an act against terrorist acts. Because I didn't use the word terrorism or terrorist, that shows you the demarcation between insurgents and terrorists. Insurgents are those who are angry with the state. They have one or two things why they're angry, and for some time they think the state is not listening to them, and so they have decided, to do what they want to do. Of course, the government of that state could use two things. Could use carrot, to take them out of it, or could use stick, or could use both. Could use carrot and stick, So because we are really not looking, well, when we go into terrorism, the state will be applying international law, and the thinking in the international realm now is that there should be a universal jurisdiction concerning terrorists. That if a terrorist is operating in Nigeria, and terrorists will go beyond a particular state, they can go into another state. That is, a terrorist can operate between Nigeria, Cameroon, Niger, Chad, like that. So lawyers are asking that there should be a universal jurisdiction. And even without them asking, I found that some terrorists that escaped Nigeria, Cameroon dealt with them, and Niger also dealt with them. So I'm not, because this is jurisprudence, and we're not in public international law class. That is why I decided to limit my example to insurgents. Am I well understood with that explanation?
Yes, ma'am. Thank you.
Okay. Do we have other questions so that I take them before I go to the next one? Do we have other questions? Morning. Go ahead.
Yes, ma'am. My question is about how international law can strong arm or trump national laws into telling the government how to deal with terrorists. Like, how is it possible? Because, for instance, a country like Nigeria now, we're a dualist country, meaning that if we sign any law at the international level, based on Section 12 and case like Faremi against Abacha, if our legislature does not pass it like an act pursuant to Section 58 of the Constitution, then um, such laws, such treaty would not be effective in the country. And I know that in that case of Abacha and Faremi, Justice Ejiomi said that the legislature cannot be, like, if there's conflict between international law and our national law, the Nigerian legislature cannot be interpreted to, the Nigerian legislature cannot make laws that would conflict with their international obligations. So that if we are to make an hierarchy of law, that ordinarily international law would supersede national law. However, we know that for law to be established in Nigeria, at least first of all, we have the constitution that creates the national government, which even now makes the ground for international law to be applicable in any way. So I'm saying that there's a conflict between international law and national law, and how international law will not dictate how the national government should treat the insurgents. So, how can we resolve that conflict, ma?
You see, do you have international law?
No, ma. But I've done some
maybe
reading on it.
Maybe that's why you have raised this. Because if you have signed a treaty, at the international plane, you can't come and say that your law says this. Yes, international law is aware of the fact that there are monostates and there are dualist states. International law is aware of that. No, no problem about that. But once you have signed a law at the international plane, you can't be coming to tell us that you will not obey international treaty. Do you understand what I'm saying? If once you have signed a law at the international plane, you can't say that you can't say, oh, this does not go with our law in my country, or whatever you want to talk about. So you can't, it will be impossible for you to be saying anything contrary. So much as I agree with some of what you have said, it's not that international law is dictating. That's why I asked you, did you study international law? And you said no. Because if you had studied international law, you would have realized that it's what in international law, what we call it, it's pacta sunt servanda. That is, every state has agreed, that this is what we're going to do, and because they have agreed on what they're going to do, then the international community is obliged the international community is obliged to, you are obliged as an international community for you to obey it, because you have already signed, you already signed the treaty. So because you have signed the treaty, it's impossible for you, to now be claiming that certain things cannot be done because of your own law. No, the international community will not accept that. And the international community has been able to see, one, that there is a problem, that there's a problem with terrorism, and this is affecting everyone. And so, Jigose, can you please mute yourself? So the international community has been able to see that terrorism is affecting all of us. And because of that reason, that's why they have brought out that treaty. So a state party cannot rely on any other thing to jeopardize the international treaty. Why? Because the war on terror, a terrorist is enemies humanis. That is a common enemy to all of us. It's like a pirate, is our common enemy, and any state party should be able to deal with it. And so on this wise, when it comes to the war on terror, we will not be looking at any local law that wants to detract from international law. I hope, Okpayemi, you get that.
Yes, ma'am. Thank you very much, ma'am.
Okay. Does any other person have questions before I move into the other segment of the lecture? Do we have other questions? Okay, let me try and recap before I go to the last leg of the lecture. When we are talking, we're still having our discussion on law, revolution, and legitimation. And we've moved to the problems of law in rebel enclave. And so I started by defining what a rebel enclave is, which is a space or territory controlled by insurgents. That's a rebel enclave. They are angry with the state. They needed some things, the state didn't do it, and so they formed themselves into a group, and they're waging war, against the state. And so they have a territory, and these are private individuals. It's not Nigerian Army, not Nigerian Police, Navy, or Air Force, So these are private authority, that is, they're private individuals forming a kind of authority in that space. And how do they fund themselves? They fund themselves through illicit channels of trade and communication. And of course, in a global village where we are in right now, to communicate is not a big issue. We live in a global village, so all of us have smartphones, all of us have, so there are several ways of communicating. Now, the question I try to answer in the last 30 to 40 minutes is about what are the problems of law in that kind of space. The first thing I identified was that law operates in a state of order. And the kind of space of the insurgents, that territorial enclave, cannot be the kind of order that law envisage. That's one. I also said that, that space that they occupy, the space that the terrorists occupy, as by the definition, it is an unrecognized state. That is, the state won't recognize that space. And because the state does not recognize that space, then it means that whatever they're doing there, how will law be enforced in a space that is unrecognized by the state? Then I also went on to say that because they're private authority, how does law deal with this kind of people? And I made incursions into international law, telling us about the Geneva Conventions and the additional protocols and its demand on such folks, And so you find that because law will always operate within the ambit of a regulated environment, that environment is not regulated. That environment, even though it exists, that environment isn't doing what it's expected or he's supposed to do. That environment is not following what it's supposed to follow. And so because of that, then we have issues. So you find that in the long run, there is a problem of enforcement of law. There is a problem of who is the hierarchy that you want to deal with. I gave an example of Gaza and the war in Gaza and with the IDF and the elimination of certain folks. But how do we deal with those folks? How do we deal with them? So these are the issues, that we are beginning to see. And these are the problems that emanate when law is dealing with rebels. There is a problem with, even if you want to have a discussion with them, who do you want to discuss with? Even though they do have their own hierarchy, but the question often is, does the law of that particular state even recognizes them? I know this portion that I'm dealing with is already happening in Nigeria. It's happening in parts of Niger State, where in Niger State, in some parts of Zamfara, in Borno, where private entities, are becoming, very unconventional with the state. And I remember one of us asked the difference between insurgents and terrorists, and I tried to give a demarcation between them, to delineate them, to say who a terrorist is and who an insurgent is. Insurgents are those who are just angry with the state. They have their grievances. But when we talk about a terrorist, there is a UN definition of a terrorist, and there is also the Nigerian Act of a terrorist, and both work together. And the Nigerian Act on Terrorism cannot invalidate the UN treaty, because the Nigerian government has signed the UN treaty, and so she cannot feign ignorance of the UN treaty. A colleague asked about us being a dualist state, and so yes, and my answer is yes, we're a dualist state, but if we have signed a treaty on the international plane, we can no longer be saying that our own local law invalidates the treaty. So having explained that, and since no one is asking any further question, I want to go to law in the aftermath of a rebellion. Law in the aftermath of a rebellion. And the question is, what is rebellion? And for us in jurisprudence, we'll always try to define our terms. We like to define our terms, because if you get the term wrong, you are likely, to get everything wrong. So because we're dealing with concepts in jurisprudence, we will always first try to define the word so that we know exactly what we're dealing with. The Oxford Dictionary defines rebellion as an act of armed resistance to an established government or leader. I'm going to take that again. It says, rebellion is an act of armed resistance to an established government or leader. The action or process of resisting authority, control, or convention. I'm giving us those definitions. Rebellion is a violent uprising against one's government. A rebel is a person who engages in a rebellion. A rebel group is a consciously coordinated group that seeks to gain political control over an entire state or portion of a state. Those are various definitions I have tried to give us. Rebellion also means opposition to one in authority or dominance. An open, armed, and unusually successful defiance of or resistance to an established government. So all those who are making noise at the background, please, can you mute your end? Please, can you mute your end? All those who are making, please, can you tell your colleagues to mute themselves or else I'll quit the class because there is a noise at the background and it's disturbing. I'm talking about law in the aftermath of a rebellion. And I have tried to define the word rebellion as it is explicit in the dictionary. And the dictionary had given us a lot of definitions about what rebellion is. And so the summary for all of us that we're going to take in the class is rebellion has to do with a group of people, that are resistant to an established government. Now, because rebellion is a form of civilian coup. Let me use that word. That's what rebellion is. Rebellion is a form of civilian coup. We haven't had that, We haven't had that in Nigeria. We haven't had, Itoro Akimbamiyi, can you please mute yourself? We haven't had that in Nigeria. We haven't had a successful civilian coup. But a successful civilian coup had taken place in Russia in 1917, the Bolshevik Revolution. The civilian coup has also taken place in France in 1789, has also taken place in the US in 1776, and Declaration of Independence and all that. We haven't really had that. But what concerns us really here is what happens to law, in rebellion. How does the law takes rebellion? That is our own, what happens to law? How does law, takes in rebellion? How does law operate? How does law operate? One of the things that happens, when we are talking about the position of law, you will agree with me that rebellion, when a rebellion takes place, the problem we will have is that how does the law react? Of course, the law will certainly not be happy in the event of a rebellion. The law will not be happy because that is not what the law envisage. What the law envisage is that men and women will obey the law. And when there is a rebellion, there are two ways that law normally act in the face of rebellion. And I did mention that even with the insurgents. They first try to see how the state, through the instrument of law, will first of all try to see how they can quell it. That's if that rebellion does not have the backing. You know, if that state of law does not have, that rebellious people, they don't have the backing of outsiders. You know, it's possible for them to have backings of outsiders. And if they do have backings of outsiders, David, can you please mute yourself? David, can you mute yourself? Akagbe David, can you please mute yourself? Akagbe David, can you please mute yourself? Akagbe David, can you still please mute yourself? I'm going to wait because there is a noise coming from your end. Anyway, I think I will end the class because this incessant incursion into the class, I don't think I'm okay with it. And I think I'll take this lecture as taken.
Sorry, please, sorry, ma. We're trying to speak to him to mute himself. Apologies, ma.
Sorry, ma. Sorry, ma. Good morning, ma. They are insurgents. We are controlling them, ma. Hello, ma.
Okay.
Sorry, ma. Sorry, ma. It's an
So-
act of insurgency. We are controlling them.
So when we look at how the law reacts to rebellion, there are often two ways which the law reacts. Most times, the law will try to bow down, you know, on the rebellious agent, you know, because the state tried to do that in France, you know, because this is a civilian coup. But of course, because the majority of the citizens were against Louis XVI, it could not work. And so when there is a failure of the state to control such rebellion, what will the state do? The state is forced, you know, to accept the fact, you know, that these folks have come to stay. You know, that these folks have come to stay, and you know, there's really nothing they can do to them. And so so what does the law? You find that the law will always try to arrange itself to accept reality. Because the law has seen that if you don't accept reality, there is a new legal order that is coming forth. You know. And because of the new legal that is coming forth, the law will now necessarily go back to the drawing board. And of course, aftermath of a rebellion, there is first going to be anarchy. There's first going to be anarchy after a rebellion, before things will settle down. And then when things settle down, then that is when, of course, aftermath of a rebellion, there will be a formation of a kind of leadership, a kind of governance, because there can be no vacuum. There can be no vacuum. So there is going to be a form of governance. And so in that disarray, there is a disarray. In that disarray, that is when law will now come forth to be able to take care of certain things. And let me, we have really not witnessed it in Nigeria. That's one of the problems that we have. But certain African countries have witnessed it, especially those African countries that had to fight for their independence. Places like Mozambique, places like Angola, they had to fight, and so they were rebellious, and they took over the apparatus of the state. They were able to defeat their colonial masters. We don't have such experience in the English-speaking countries. We didn't engage, with colonial masters. We got our independence through conferences, talking, engaging with one another. That's how we got our independence. So, law, one of the problems that we will realize is that law, like, because I'm a law and development student, law often purports to be very powerful. And law gives an impression that it can solve all problems. It also gives an impression that it can tackle anything. For example, law will say, oh, law comes to you from cradle to the grave. That is, once you are born till you die, law operates. But there are certain times that law becomes an impotent tool. Why? Because the civil disobedience is making law to be ineffective. And that's always what comes to fall in the aftermath of a rebellion. Law will struggle to come back to reckoning. Let me use that word. Law will struggle, to come back to reckoning, because invariably it is law that people fought against. It is law that people fought against. If there is a rebellion, what made the rebellion to come? The rebellion came because people were angry, with a certain law. Take, for example, what happened in Alabama when Rosa Parks decided not to stand up. There is a law that if a Black person is sitting in the front of the bus after the driver, and a white man comes in and the white man does not have a seat, and the Black man or Black woman, a colored person anyway, we have to rise up and give space, to that white man. It was a law. And that law was going on until the incident of Rosa Parks, that a white man came in and the Rosa Parks refused to stand up. That became an issue. She was taken into custody, and she was taken to court, and she was sentenced, and that caused a very strong uprising. Now, let me even use another example that we should be able to relate with. The Arab Spring is a very good example of what we're talking about now. The Arab Spring started from Tunisia, where a certain young man was dissatisfied with the state and set himself ablaze. And of course, what happened? The president of Tunisia saw handwriting on the wall and decided to quit. And that was how the uprising started. got to Egypt, got to, I know that's how it was going. But when it got to Libya, Muammar Gaddafi did not accept it. And he tried to quell it. But what happened? He was not successful, and we all know the story of what happened to Muammar Gaddafi. Now, in all these examples that I have given us, one thing comes to the fore in all those examples, which is the fact that when rebellion takes place, for us, for the society, and when I say us, I'm talking about the society, for the society to be able, to come together after that aftermath, there's certainly going to be some kind of effort. It was law that was fought against, but we still need law, to be able to keep the society in place. Because no society can really have progress without the instrumentality of law. So what happens that law now becomes, as we know, a two-edged sword that is often used. It could be used negatively and it can be used positively. But in the aftermath of a rebellion, law sets out to make sure that the society comes back to its original state. That is the first role of law. All law will be concerned with is that how can we get our state together again? How can our state be what it used to be? And so you find that that is what law, in most cases, will be struggling with. That's what law will be dealing with. I want to stop now a bit, and we have 12 more minutes. I just want to know whether peradventure my explanation of law in the aftermath of a rebellion makes sense to us, and if we have any question that we want to ask.
Thank you, ma. Good morning, ma.
Morning.
Well, maybe I want to step back a bit in the issue of when a rebellion or insurgency has a backing. Most often is by a foreign organizations. So at this point, I want to ask, ma, would criminality still be attached to a situation like that? Because it becomes difficult to say you want to be trying people who have foreign body, who have foreign backing for the actions or for their anger they have against a given settled statement.
In that wise, one of the if they succeed, if they succeed, what normally happens if they succeed, they get away with it. Let me just use that word. If they have foreign backing and they succeed, they get away with it. Do we understand? But if they don't succeed, that's when the state, that they are fighting against, can now, well, in most cases, maybe report, to the international community, that this is what happened, you know, and this is, you know, they might be saying, oh, this is what happened, this, so, and we don't like this. And they may have the sympathy, you know, they may have the sympathy of other states, you know, other third-party states, you know, they may have their sympathy, you know, about it. So, but you find out that once those foreign elements, let me use that word for them, those foreign elements, once they are aware, you know, that once they are aware that it's not going on well, they may back down, you know. Of course, you know, I don't know if you're offering international law. One of the problems that international law has is the fact that in such matters, they're going to make speeches, but unless the Security Council, under Chapter 7 of the UN Charter, decides to go after that other state that is backing terrorists, that's when and something can be done to them. But if the Security Council is silent about it, then they may get away with whatever they have done. It may just go like that. If they didn't succeed, it just goes like that. But if they succeed, you know, there's nothing anybody can do to them again. They've succeeded, and they will be able to put in their stooge, you know. They've already tried to make that government not to be as powerful or as effective as should be.
I have a question, ma'am.
Yes, go ahead.
So you said what happens after rebellion has taken place is that law set out to make sure the society comes back to its original state.
Yes.
I would like you to elaborate on this because when you that statement, like it brings to my mind as if, okay, you are trying to say, okay, the society or the law is trying to, like, okay, go back to how it was before this rebellion took place. Or is the law trying to reconstitute the society in such a way that it incorporates like the solutions it had for the rebellion in the first place, or is just trying to like go back to its original state, thereby not actually bringing remedies to what actually brought about the rebellion in the first place?
You know, aftermath of a rebellion, which I didn't say, and I was silent, but aftermath of a rebellion, or really after any war, no matter how long the war takes, state parties will still sit down and talk at a table. No matter how long the law is, state parties will still sit down and talk. And so it is at that process that things are ironed out. That's when, if the rebellion is successful, of course, the rebellious, they are now the legitimate. They take over reins of power and whatever they want to do. And that's what happened in the Bolshevik Revolution. That was happened in Angola, in Mozambique, you know, when the Mozambicans, even Robert Mugabe, when they were able to wrestle power from Ian Smith and change their name from Southern Rhodesia to Zimbabwe, you know. So they formed the new order. And when there's a new order, there is the likelihood that the new order goes to restructure the society and to resuscitate the society for the good of all. And the instrument that will be used is also law. The instrumentality of law will always be what will be used at any point in time.
Good morning, ma'am.
Morning.
Yes, I have a question.
Go ahead.
Yes, ma'am. But the question is on law and justice. I don't know if I'll be permitted to ask. It's not on today's
Law
topic,
and
ma'am.
justice.
Yes, ma'am. Yes, I wanted to ask that in a situation whereby we are asked to give an analysis on the difficulties in constructing a universal concept of justice. Let's say, aside defining what justice is and then giving our own perspective of what justice is, because I remember in class you talked about that our own perspective of justice is going to be based on our own personal experiences. So let's say after defining justice and then giving a notion of justice based on our own perspective, what other essential aspects do you think we have to include for us to give a robust analysis on the problems of creating or constructing a universal concept of justice, ma'am?
Sister, I am not going to answer this question. I hope you will not be disappointed because it is for you to go and do your research. Because you want me to answer a question that is likely to come up in exam. I'm not going to answer it. I hope I'm not.
Please, I have a question, ma.
Go ahead.
So earlier on you said there are two ways law reacts in the face of rebellion. And you mentioned the first one. You said the law seeks to see how to quell rebellion. That is, it tries to like hit down on the rebellious agent. So my question is, I don't know if you mentioned the second one, but I didn't like because I was writing even afterward, but I can't seem to see like the second way you mentioned.
I talked about carrot and stick. I hope you remember about carrot and stick.
Okay.
So there are two ways law operates in that kind of enclave. It's either law use carrot and stick, or it first use stick, and when it sees that stick is not working, they now use carrot. If you are offering public international law, you will understand my concept of carrot and stick, because that is always what international law normally resort to, most times when they have seen that they've tried all the other ways and it's not working, and then they try to use carrot, is not working, then they use stick, is not, then they use carrot and stick. That is, they use both encouraging means, like say, okay, we're going to do this for you, and we're going to do this for you, we're going to do this for you. Or they may also go after the supposed culprits and deal with them. Law can also try, to do that as well. Do you understand?
Yes, ma'am. Thank you.
Okay. So we have 1 more minute, and in that 1 more minute, I just want to do a recap. The whole essence of the lectures that we have had in the last 3 weeks or so has to do about law, regulation, and legitimation. And what is all that about? It's all about society, how law responds to issues in the society. Law definitely has an idea about itself in the sense that it has a stable order. But in reality, certain things happen that quells the stability of the society. And that's what we have tried to look at in the overthrow of legitimate government, in what law has to do with in a rebel enclave, and even aftermath of a rebellion. I think what we need to take out of everything that we have done is the importance of law at all times and in all purposes. And that whether there's a rebellion, whether there's an insurgency, whether there's a coup, or that law remains constant, and that law cannot be wished away. We need to have that at the back of our minds, the importance of law and what law has set out to do. So on that note, we'll end the lectures on law, revolution, and legitimation. And I hope we will read further on our own and have a fuller understanding than what we may have discussed in class.
Thank you so much, ma'am.
Thank you, Ma.
Thank you so much, Ma. God bless you.
Mhm.
One already.